and second Abubakar. The accused person is the court my lord, and the matter is coming up for
Different Moses. Criminal case number 4 of 2029. Just J.D. Capitz, as he then was, observed that Section 52 of TIA, which is now Section 51(2) of TIA, is observed that this section empowers the court to make an order for declaration of the indictment as the court thinks necessary to meet the circumstances of the case. In other words, the court is empowered to amend the indictment. Based on the above provisions of the law and the authority cited above, I am satisfied that the amendment I am about to make does not cause any injustice to the accused persons. I will therefore order for the amendment of the indictment without necessarily prosecution having filed formal application, and I will make the following directions. 1. The prosecution is directed to amend based on the objections raised by the defense to amend under Section 51(2) of the indictment. And specifically, the prosecution should amend the indictment in respect of the particulars of S3 on the proper names, age, and rank. B. The prosecution is further directed to amend the notes attached to the indictment, which was not signed and dated, enable the register to sign it and date it. C. For count 2, which is misprision of treason as separate offense, in my view, this does not cause any injustice to the chosen person. In any case, the prosecution, if they so wish to charge the chosen under this offense, to me, as long as it does not cause any miscarriage of justice, it can stand. D. The prosecution, therefore, is given 15 minutes from now to amend the indictment and finally on court record. 2. The assistant registrar is directed to sign and date the amended indictment within 5 minutes. 3. The assistant registrar is directed to serve the amended indictment after signing and dating it to the chosen persons and their counsel together with the prosecution within 10 minutes. In the final results, the accused person shall take plea on amended indictment, and the defense is given 15 minutes after being served with amended indictment. They are given 15 minutes to engage with their clients, and plea will be taken thereafter. Before I take leave of this matter, I wish to advise and guide the defense team that for the interest of justice, and specifically the interest of their client, let them allow their chosen persons to bring the charges against them. If the defense now has any concern or any issue, the same concern or any issue will be handled during scheduling, of which scheduling both parties will have a chance to inform court how they want this scheduling to be done. Otherwise, an order as above the issues. This is the ruling of court arising from objections of counsel for the accused persons that the indictment is effective. I listened very carefully and I have put into consideration all the gross submissions of both parties. But briefly, counsel for accused persons raised 4 objections that the indictment is defective. 1, that the indictment is defective because it does not contain specific particulars of S3 as per section 23 of PIA. 2, that the indictment was not signed and dated as per section 28(1) of PIA. 3, that the indictment was not duly served the accused persons as per section 61 of PIA. And lastly, that the indictment is defective because it includes count 2, which is misprision of prison as a separate offense. Yet, it should have been an alternative offense. On the onset, I want to state that all the oral submissions from both parties have been put into consideration, and the same are on court record. I did not therefore reproduce them. I will now proceed to make the following remarks and findings basing on the objections raised by the defense. That as far as the declaration of indictment is concerned, this honorable court will be guided by section 51(1) and 51(2) of the TIA. Section 51(1) of TIA provides that every objection to an indictment of any form of defect on the face of indictment shall be taken immediately after the indictment has been read over to the accused person and not later. Hence this ruling. Section 51(2) of TIA provides that where before a trial, upon indictment or at any stage of the trial, it is made to appear to the High Court that the indictment is defective or otherwise requires amendment, the court may make such an order for the declaration of the indictment by way of its amendment. Basing on the oral submissions of both parties, it is not in dispute that counsel for the accused persons submitted that the indictment before court is defective. Likewise, it is not in dispute that the state indicated that given opportunity, it requires to amend the indictment. All these concerns were brought to the attention of this honorable court. From the submissions of both parties and the circumstances of this case, it is made to appear to this honorable court that there is a need for amendment of the indictment as long as it does not cause any miscarriage of justice. It is my considered view and opinion that section 51(2) specifically of TIA gives court powers to order for amendment of indictment, especially if court deems it fit and necessary to amend the circumstances of the case, as long as the amendment does not cause injustice to the accused persons. Article 126(2)(e) of the Constitution of the Republic of Uganda provides that in adjudicating cases of both civil and criminal in nature, the court shall, subject to the law, apply the following principles. Briefly, E, that substantive justice shall be administered without undue regard to legalities. In my view, what matters when looking at the amendments or alterations of indictment is whether the amendment can be made without injustice and without touching the merits of the case. As long as the amendment does not touch the substance of the offence, declaration can be ordered.
Brian, tuli nawe sekanjako Abubakar wanda sekanjako Abubakar.
Nsonga y'omulamuzi gy'asitula
omulamuzi eddakiika 5 zaawa omuntu okubeera nga bamuwadde indictment ennaku zibeera 15 eziweebwa kati bw'aba ng'asazeewo nti waaliwo ensobi akkirize amala okola amendment okugenda alyokawe abawawaabirwa toyinza kusoma kiwandiiko mu ddakiika 5 n'oba ng'omaze okutegeera kikyolina okutegeera asooka abawo obwo obudde ennaku 15 ezikkirizibwa mu mateeka tebannabaga nti tebajja kuba talina kimupapya talina gy'alaga.
Kati entambuza y'omusango guno ogyogerako ki?
Entambuza y'omusango singitegeera nze nga nze tetegeerekeka kuba buli nnaku ebaamu ensobi kati ng'omulamuzi omukulu bw'ati tuba tusuubira okuba nga buli kintu kiba perfect.